Hello, my name is Alma Robinson, and I am the Executive Director of California Lawyers for the Arts. CLA is a statewide nonprofit organization that was founded in 1974 to serve artists and arts organizations of all disciplines with advocacy as well as services that provide support with legal and business issues. With staffed offices in San Francisco, Berkeley, Sacramento, Los Angeles, and San Diego, we provide several core services. First, we provide legal counseling to specialized attorneys who provide assistance with a variety of intellectual property questions, as well as contract reviews and negotiations and other important business issues. Depending on the client's financial status, legal assistance may be available on a pro bono or reduced fee basis. We also provide a specialized program that assists independent inventors and small startups with their patent applications. To help with situations involving disputes, we provide a range of alternative services, including negotiations counseling, mediation, and arbitration that can avoid the expense and hassle of going to court. Finally, we offer a full menu of educational programs that include workshops, symposia, and conferences on various legal topics for artists and arts organizations. Many of these programs are posted on our YouTube channel, and we encourage you to use these tools to educate yourself on the legal issues before you reach out for specialized assistance from our organization. Thank you for joining today's program. And please consider joining CLA on our website at www.calawyersforthearts.org so that we can continue to maintain our full range of services. Thank you.
People who maybe don't have very much familiarity with the patent process. So first, where do patent rights come from? It's different for each country, but in the US, it comes from one section in the Constitution. It's Article 1, Section 8 of the Constitution. It says that Congress has the power to promote the progress of science and the useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. So that one sentence from the Constitution has been the grounds for all of the patent law in the United States. And from that, we've started the United States Patent and Trademark Office, which generates millions of patents. So what's the purpose of patent law? Really, the main purpose of patent law is to encourage inventors to explain their ideas or inventions to the public. And the way that the federal government encourages inventors to do that is by giving them some exclusive rights to those inventions for teaching them to the public. So a patent application needs to include all the information that's necessary to educate the public about an invention. So you can't file a patent application on some invention, but then keep some key element of the invention secret. You're required to provide all of the information that one of ordinary skill in the art could then use to go and practice the invention. So you really need to be teaching it to the public, but it's not to someone who has no level of skill in whatever that art is. It's someone who's already skilled in the art and presenting them with new information that upon reading that, they could go and, without too much experimentation, practice the invention. The idea is it allows the public to learn from the inventor's technology, and then the public can then come up with their own inventions. So it's a mechanism to advance technology. So in exchange for teaching the public the invention that some inventor has come up with, what does he receive? He gets a set of rights or a monopoly to his technology or her technology. Now, a patent, it's good for 20 years from the filing date of the patent. And so you file a patent application, it gets examined, hopefully eventually it gets allowed and issues as a patent. And then it's good for 20 years from the filing date, not from the date that it's granted, but from when it was originally filed. Generally takes about 3 years, give or take, for a patent application to issue into a patent from when it's filed. So you get around 17 years of life of a patent after issuance on average. And upon expiration of the patent term, the technology then enters the public domain. That means anyone is free to then practice that invention. So the idea is an inventor teaches the public how to do something, what this new great technology is, and then he gets to be the exclusive user of that technology for the term of the patent. And after it expires, everyone can use it. So it benefits everyone. The patent rights that are granted or that come with the granting of a patent are the right to make, use, sell, or import a technology. And like this is the exclusive set of rights that only the patent owner has. A patent owner can then choose to sell one or more of these rights or to license one or more of these rights to some other party. So if you have a patent on something and some other company wanted to obtain the right to then maybe manufacture some product that you invented, then you could reach some kind of licensing agreement where they pay the owner of the patent some royalty rate or some percentage of the profit that they get on every widget that is sold, for instance. So one thing that is important to know is that patent rights are jurisdictional, and that means that if you get a patent in the US, that doesn't protect you from any activity outside of the US. So if someone tries to make the patented technology in the US or use it in the US or sell it in the US or import it into the US, you could stop that activity with a US patent. But for instance, if you had a US patent and someone tried to make the patented product in China and then sell it in Europe, you can't do anything about that activity because it doesn't touch US soil. So in that case, no one is making, using, selling, or importing it into the US. So there are a few examples that I provided of a new invention. And these are just hypothetical, though they have some limited bearing on what's actually happened in the past. But so for this first example of an invention, let's say Nokia has invented a mobile phone, and then Palm separately invents a touchscreen personal digital assistant. And each of Nokia and Palm gets, let's say, one or more patents on their respective technology. Now, Apple comes along and they invent a smartphone. And so at its core, a smartphone is basically a combination of a mobile phone plus a touchscreen PDA. So if the smartphone is a type of mobile phone, then Apple could not then manufacture, use, or sell the smartphone in the US because they would be infringing on Nokia's mobile phone patents. Similarly, they would be infringing on Palm's touchscreen PDA patents. So even if Apple, in this case, were to get a patent on the smartphone, which they could do because it in this example, it's something new. It's something that combines a mobile phone plus a touchscreen, which had never been done before based on this scenario. So let's say Apple gets a patent on the smartphone. Having a patent on something doesn't give you the right to actually practice your technology. It only gives you the right to exclude others from practicing your technology. So whether or not you can practice your own technology is based on patent rights that others might have. So in this scenario, Apple would not be able to manufacture smartphones or sell them in the US without first licensing patents from Nokia and from Palm. However, Nokia and Palm would not be able to manufacture or sell smartphones because the smartphone patent in this example is something that Apple has. And so you have something called blocking patents where nobody can practice the new invention without licensing the technology from each other. So why are patents important? There are a number of uses of patents. Companies use them defensively to protect their technology and make sure that no one else can file patent applications on that technology. And they could use it to prevent competitors from entering a particular market. They can also use them offensively. If you're a patent holder, you could actively sue competitors to prevent them from making, using, or selling your technology. You could also try to generate revenue from your patents based on getting other entities to license your patents or by suing other parties who are infringing your patents and then getting a court to award you some amount based on that use of your patented technology. Often, especially for startup companies, the patent is also considered a company asset. A patent is it's a form of intellectual property, and it's often one of the core company assets for startup companies. And it can help to attract investors. If you can show that you have patented technology, then it shows you have something new. There are two main types of patents in the US, and that's utility patents and design patents. There's also something called plant patents, but that's a specialized patent for basically new strains or breeds of plants. And it's not something we're going to be discussing today. But a utility patent protects the functionality of some process or thing or article. And it could be the way the article is used or the way that it works. And utility patents are the most common and generally considered to be the most valuable type of patent. There are also design patents. And design patents, in contrast to utility patents, they protect the look and feel of something. So a design patent can't be used to protect how something functions. Like if you invented something that performs some brand new function, it would be inappropriate to file a design patent on that. However, if your invention that performs this new function could perform it in many ways, and you have a particular ornamental design or configuration that you've used for it, then you could potentially protect that design with a design patent. But it has to be separated from the functionality. If the design is directly related to the functionality, then again, a design patent is probably not appropriate. As I mentioned, utility patents are the most common type of patent, and they're also the most common type of patent application that the pro bono attorneys who help low-income inventors through the California Inventors Assistance Program help with. Utility patents generally would protect an invention better than a design patent because design patents are generally construed very narrowly. So all you have to do is modify a design slightly, and then you're not considered to be infringing the design patent. Whereas since a utility patent protects functionality, you could change the actual implementation in many ways, and as long as it's still performing the same functionality, then it would infringe. So utility patent, it includes a detailed technical disclosure along with drawings of the invention and one or more claims of an invention. So we'll go into a little bit more detail later in this presentation on what the contents of a utility patent application are. But it's really broken down into those three components. Generally, the claims are considered to be the most important part of a patent, though the other parts are important as well. But it's the claims that define the scope of the invention. It's the claims of a patent that a court looks at to determine whether someone infringes the patent and to determine kind of the four corners of what is actually protected. So what can you file a design patent application on? Under Section 35 USC 101, it's any new and useful machine, article of manufacture, process, method, composition of matter, or improvements of any of these things. Most inventions, you should know, are actually improvements on existing technology. It's pretty rare for completely new technologies to be developed and to see patent applications on those completely new technologies. So you should know that the bar for getting a patent is generally lower than most engineers would think. It just has to be some new tweak on something that's been around where your new tweak provides some kind of improvement. For a processing device or processor, 99% of the processor might be the same as it was before, but you figured out one little improvement to how the circuits are routed or how the transistors are working or something along those lines. And maybe that provides a 1% improvement in power efficiency or something. that would be enough to get a patent. And courts have interpreted, this list of things that are patentable to basically include anything under the sun that's made by man. So if something has been manufactured by man, came up with something, chances are it's patentable. That's assuming that nobody has done something along those lines before. Design patents, as I mentioned, they cover ornamentation or the look and feel of an article. So it'll cover configuration or shape, surface ornamentation on an article, and a combination of the configuration or shape plus ornamentation on the surface of an article. And you can get design patents on any part of an article. It doesn't have to be the complete thing. So like for instance, you could get a design patent on a butterfly shaped chair, or you could get a design patent on some paper that has a fancy, unique background on it. Unlike a utility patent application, which generally has a very detailed written description of the invention explaining how it works, and an accompanying set of figures showing how it works, and then the claims. A design patent application has a very, very brief description, basically just listing the figures, and it has very detailed figures that have quite stringent rules on how the figures are drawn, where the rules on how to draw the figures for design patents are actually much more stringent than those for utility patent applications. And then has one claim that's basically claiming an article as shown in the figures. So what's patentable for design patents? It's basically any new, original, and ornamental design for an article. Doesn't matter what it is, as long as the ornamentation and or the shape or design is new. And to be new, that means that no single identical design exists in the prior art. Generally, it's much easier to get a patent granted if it's a design patent than a utility patent, because all your design has to be is slightly different from everything that was designed before. And you'll probably get a design patent issued. So for both design patents and utility patents, they're broken down into these three main parts: the specification, which is the detailed description, the drawings, and the claims. The detailed description is a plain English description of what the invention is and how it works. Generally, you want it to be very detailed. You start with a broad description of what the invention is, and then you narrow it down in steps. So you have kind of a medium level description and then low level description, including examples and alternatives of the invention or of implementations of the invention. Then the drawings, there's actually no requirement for a utility application to include drawings. However, an examiner can require them if he feels that they are necessary for the understanding of the invention. It's always recommended to include drawings because you can't add new matter to a patent application after it's been filed, and you don't know whether an examiner will hold the opinion that drawings are necessary for understanding the invention. So you should generally assume that they are necessary just to be safe, though technically you don't have to have drawings. Finally, there's the claims section. And as I said earlier, that's the most important part of the patent. And that's the part that the examiner is actually going to look at mainly when he's reviewing your patent application and determining whether your invention is patentable. And the claims define the legal scope of your invention. In order for an invention to be patentable, it has to be both novel and non-obvious. So what it means to be novel is that the invention, all of its features have not been disclosed in a single prior art reference. Novelty is generally a pretty easy hurdle to overcome. If you've come up with something new that no one has done before, you should pass the novelty bar. The non-obviousness bar is a little bit trickier to overcome because you have to show that it would not have been obvious to come up with your invention. And so for an obviousness type rejection, an examiner will find multiple references. So assume that your invention is novel and there's no single reference out there that teaches what you do, what your invention is. But there are multiple references that each teach a part of your invention. Now, if it would have been obvious to combine those multiple references to arrive at your invention, then your invention's not patentable. And so that's the tricky part, is convincing the patent examiner that it wouldn't have been obvious to combine some combination of references to arrive at your invention. Because obviousness is kind of a tricky concept to fully understand, I have a few examples of inventions that would or would not be considered obvious. So in this first example, let's assume that there's an invention, which is an application, like an application on a computer, that A, searches for the cheapest airline reservation, and B, sends an automatic email with a search result. So let's assume for this example that there's a prior art reference, D1, that is an application that searches for the cheapest airline reservation. But no one has ever combined A and B. So no one has both generated an invention that both searches for cheapest airline reservation and then sends an email with the result. However, a patent examiner would probably consider this obvious, because any average programmer would recognize how email works and that automatic results of lots of types of searches have been emailed in the past, and they would recognize that you could easily automatically send email results of searches for cheapest airline tickets. So even though no one had come up with an application that searches for cheapest airlines and sends emails of the results for this example, it still wouldn't be considered patentable. Okay, so here's a little more complicated example. In this example, we have a new invention, which is an application that searches for the cheapest airline reservation and also searches for the cheapest rental car. So let's assume that there's one reference that's an application that searches for the cheapest airline reservation, and another reference, which is an application that searches for the cheapest rental car. And we can assume that no one has combined these two things. Again, an average programmer looking at both of these references would have been able to easily combine searching for the cheapest airline reservation and searching for the cheapest rental car. The invention hasn't really added anything new other than combining these two concepts, which a programmer would have easily been able to do. So again, this wouldn't be considered a patentable invention because it would be considered obvious. All right, so let's go into an example where the invention probably would not be considered obvious. So let's assume there's an invention which is an application that searches through car and airline databases to identify an airline reservation and car rental combination that maximize frequent flyer mileage. So there's a lot more steps behind this combination where you're actually making some decisions and ranking different things and comparing those rankings and making some kind of conclusion, determining something that, making a conclusion at the end. So let's assume that there's a reference that searches for the cheapest airline reservation and a reference that searches for the cheapest rental car. However, that there's no reference that has taken a combination of these two things and then determined from those searches a combination of the search results that would maximize frequent flyer mileage. So the non-obvious nugget here would be identifying the optimal airline reservation car rental combination, which is a qualitatively different result than the prior two references provided. So this would probably be considered patentable. Okay, so since you guys are online through the California Inventors Assistance Program, I thought it might be useful to spend a little bit of time talking about what pro bono patent work is and how you might be able to take advantage of it. So for patent legal services are generally really expensive. To pay a patent attorney to draft and file a new utility patent application generally costs roughly $10,000 to $15,000 in attorney fees. If you opt for what's called a provisional patent application, which we haven't gone into yet, it'll cut the cost down to about $2,000 to $5,000 in attorney fees. But you still eventually have to file a full utility application, which again would be the $10,000 to $15,000 in attorney fees. And then also, even after you file a patent application, there's additional work that needs to be done in order to turn a patent application into an issued patent. There are generally multiple rounds of interaction between the applicant and the Patent and Trademark Office. And a patent attorney will usually charge somewhere around $2,500 to $5,000 in attorney fees for each round of interaction with the Patent and Trademark Office. So to pay for a patent application from filing to final issuance of a patent generally costs, roughly $20,000 to $30,000 in attorney fees. Okay, so that is really expensive for most people. That's where pro bono patent help comes in. So if you get help on a pro bono basis, that means that attorney fees are waived. So that means all of these high dollar amounts drop to zero. In order to qualify for pro bono assistance, you need to apply to either with California Lawyers for the Arts for the admittance into the California Inventors Assistance Program, or there are other regional patent pro bono programs around the US, depending on where you're located. They will go through a screening process to make sure that you qualify to get pro bono help. And assuming that you do, then you get placed in a list and attorneys can review that and take up your case, and if it's one that interests them. And then once they do, all of these legal fees are zero. But that doesn't mean that the application is free. There are still other non-legal fees, or non-attorney fees, I should say, that you need to pay if you're filing and prosecuting a patent application. So the first fees that you need to be concerned with are application filing fees. Anybody who qualifies for the Patent Pro Bono program generally will also qualify for what's called micro-entity status. And that means that the fees charged by the Patent and Trademark Office are quartered. However, if for some reason you didn't qualify for micro-entity status, then you would almost certainly still qualify for small entity status, in which case the patent and trademark fees are halved. And that the standard fee for a regular entity, which is a business entity that has more than 500 employees or 500 or more employees, is generally around $1,800. So it's around $900 if you're a small entity and around $450 if you're a micro entity. There are other fees associated with filing a patent application as well. Sometimes a draftsperson is required to actually draw up the figures, and those fees are not waived. So a draftsperson generally charges anywhere from $60 to $100 per sheet when they're preparing figures. And that amount actually goes up if you're filing a design patent application, because the figures are generally more complicated for design patents and the rules are more stringent for them. And there's also generally more figures for a design patent. So what that means is the patent pro bono help is not as beneficial for design patents as it is for utility patents, because the bulk of the fees for a design patent application are drawings fees plus Patent and Trademark Office fees, and not attorney fees. So that means only a small percentage of the fees associated with filing a design patent application are waived. Whereas for a utility patent application, a bulk of the fees are attorney fees. And so you're erasing a bulk of the fees if you get pro bono assistance for a utility patent application. So briefly, the patent process is you draft and file a patent application. Generally that takes, you meet with an attorney, and it'll take around 3 months from that first meeting for them to draft up a version of the patent application for you to review. And then they will, if there are any edits that are necessary, there will be one or more rounds of revision. Then once you're happy with the application, it'll get filed. And then you get a filing date associated with that. And if anyone else were to come up with a similar invention and try to file on it after your filing date, then your application would take precedence. One thing to note is that in the US, you get 1 year from the first public disclosure of your invention to file a patent application on that invention. So that means, if you write about your invention online, or you show it to a group of people, or you have a presentation on it, or you tell a group of people about it, that starts a 1-year timer in the US. And you need to file your patent application before that 1-year timer runs out. Now, that's not true in other countries. Most countries actually require that you file a patent application before the first public disclosure, which means you could be in a situation where you are permitted to file a patent application in the US, but not outside of the US. If you're qualifying for the patent pro bono assistance, you probably don't need to worry about this, because foreign prosecution of patent applications is really, really expensive. It's even more expensive than getting patents in the US. And so you're probably not going to want to spend the money that it would cost to get foreign filing. And also, generally, attorneys that provide pro bono legal services through the California Inventors Assistance Program and the other pro bono patent programs don't offer to help with foreign filing of applications on a pro bono basis. So once the application is filed, the Patent and Trademark Office will send out a filing receipt. That will give you an application number and a date that it was filed, and have some other relevant information on it. And if there are any defects in the application, the USPTO will mail out a notice to correct the application. And you'll get a certain time period in which you need to correct any defects that they identified. And if you don't correct those defects within that time period, your application is deemed abandoned. Assuming there are no defects, or any defects were corrected, then the application is eventually assigned to a patent examiner. It generally takes around 1.5 years from the filing of an application for the application to be assigned and then examined. And then once the patent examiner examines the application, they will issue what's called an office action. Generally, the office action will include one or more rejections of your application. That's not something to worry about. 99% of patent applications receive office actions rejecting all of the claims. But then after you receive a rejection, you have a certain time period to respond to that office action. And with that response, you can amend the claims, or you can argue against the rejections. And if your arguments are successful, then the examiner will do an updated prior art search and then generally send out another office action. And there are multiple rounds of this back and forth generally, until ultimately either the examiner finds some prior art that's so close that you decide, you know what, this isn't new, and then you abandon your application, or the patent examiner says this is new and novel and non-obvious, and they issue a notice of allowance. Once a notice of allowance is issued, the applicant has a set time period to pay an issue fee to avoid abandonment of the application. And once the issue fee is paid, then it takes about a month, and then the patent application issues into a patent. Now, that's not the last that you have to interact with the Patent and Trademark Office. Even after you have a patent issued, you still have to pay periodic maintenance fees to avoid having your patent go abandoned. So you have to pay maintenance fees at 3.5 years, 7.5, and 11.5 years from the date of issuance. And the fees get progressively more expensive. So the 3.5-year fees are much less than the 7.5, which are much less than the 11.5-year fees. So I have a few examples of patent applications of companies that you might be familiar with. And these are kind of some of the seminal early patent applications that they filed that describe the technology, basically that the company was built around. So here's one of the early patents from Dropbox. It's a patent on network folder synchronization that details how multiple clients can share and synchronize folders and their contents across a network. Here's one of the early seminal patents for Square. It's a system and method for decoding card swipe signals, from credit cards. And you're probably familiar with Square devices that basically anyone can buy one of these devices and plug it into a smartphone or a tablet, and suddenly they can accept credit card payments. There's also a few examples that I provide of some design patents. You might recognize this is a design patent for the MacBook Air. So you can see that the design patent is covering the shape of the MacBook Air, where it's thicker in the back than in the front, and it has this kind of curved surface where it's highest in the middle, and it has a few ports on the side. So if any other laptop manufacturer wanted to make a new laptop, they could not make the laptop look exactly like this MacBook Air that's covered in this design patent. And you might note that some of the lines in the design patent drawing are dashed and some are solid. That's actually really important for a design patent, because for a design patent, you're actually only claiming what's in solid lines. So these dashed lines you see in the front, that portion is not being claimed. So that means, the MacBook Air actually has kind of a small indent, what makes it easier to open the laptop. They're not claiming that indent. So a laptop that was shaped just like the MacBook Air, but didn't have that indent, would still infringe this patent. And I can't tell from this picture, but most likely the ports on the side are also shown with dashed lines, because ports often change, and you generally wouldn't want to protect or cover the ports in a design patent application. You can also get design patents for user interfaces or views of a graphical user interface, for an application that runs on a computer or phone, for example. So this is another Apple design patent, and this one is covering the ornamental design of an animated graphical user interface for a display screen. And you can see in this design patent drawing, it's shown on an iPhone, but the design of the phone is completely dashed out. And the only thing that's actually in solid lines are these rectangles and the relationship of or squares, of the front square and then the squares on the side. So if anyone tried to have a user interface that had this sequence of a square in the front with kind of side squares that are oriented to the right on one side and oriented to the left on the other side, they might infringe this design patent. And then also Google got a design patent issued on their homepage. And you can see that the word Google is actually dashed out, and some of the words on this are dashed out, but other words are solid. So if another company came up with a web page that had a search bar that looked just like this, with a sequence of words above the search bar as are shown, and then two side-by-side buttons for searching, and then some additional items below, as you see here, they would potentially infringe that patent. So that's the presentation in a nutshell, except, I forgot to mention on provisional applications. So provisional patent applications are basically a placeholder patent application that gives you 1 year from the filing of the provisional application to then go and file a full utility patent application. The nice thing about provisional applications is that there are no requirements for what you include in the provisional application. Patent and Trademark Office doesn't examine them. All they do is stamp a date on them based on when they received that application. So that's also happens to be one of the downsides of a provisional application, because you only get protection for what you're actually describing in a patent application. And generally, provisional applications include a lot less content than a full utility application. So the protection that you're getting for a provisional application is going to be less than the protection you're getting for a full utility application. So you have to be careful if you're filing a provisional application that it still has a full detailed explanation or description of your invention. That being said, provisional applications are generally much less costly and much quicker to file than full utility applications. However, if you're participating in the California Inventors Assistance Program, you probably don't want to go the route of a provisional application, because since you don't have to pay the attorney fees, you might as well have a full utility patent application drafted, unless there's some rush to get an application on file. Because if you go with a provisional application, you're still in a year's time going to have to go back and find help to draft the full utility application. I have a set of questions that have been sent in while I was talking. So let's see if I can talk to some of these questions. Okay, so the first question is, what can be patented when it comes to improving an existing product? So I think I covered this in the presentation. Basically, it has to be something that is both novel and non-obvious. So novelty is generally an easy bar to meet, but the non-obviousness portion can be tricky. So there was an example in the question that said, for example, an eraser added to a pencil was not granted. So I presume that the prior art that was found was an eraser and then a pencil separately, and there might have been some prior art of some other type of writing implement with an eraser attached. Based on that prior art, I can see how a patent application on a pencil with an eraser would have been rejected, because a pencil is just another type of writing implement. So the basic functionality of being able to write and erase from the same implement, in that case, would not have been new. How broad are design patents? So design patents are by their nature very narrow. In order for someone to infringe a design patent, they basically have to copy your design almost exactly. That is why they're not nearly as common as utility patent applications, because they're so easy to design around. However, they can be valuable, especially for like large companies that have well-known products, because like companies want to make knockoff products that look just like the well-known product. So companies will file design patents to prevent knockoff products that look just like their product. What is needed for provisional filing? So I covered this briefly. So for a provisional application, there are no requirements as to what you include. You could include a PowerPoint presentation and just put a cover page on it with your name, and that could be the contents of your provisional application. You could have, a bunch of photographs that you scanned into a document, and you could submit that, and that could be your provisional application. That being said, it's a good idea to have as much description in a provisional application as possible, because if you don't have a good description of your invention in the provisional application, you're not getting very much protection. It's not going to be a very valuable provisional application. If you write a simple provisional patent with not much detail describing your invention, and then write more detail for the full patent, do you have the same level of protection as if you put the details of your invention in the provisional patent? No, you do not. If you only have any additional subject matter that was added when you file the full application or full non-provisional application, only has the priority date of that application. It does not have the earlier priority date of the provisional application. Only what you described and in that provisional application has the priority date of the provisional application. So that's why provisional applications can get you into trouble, because you can lose the priority date for any new matter that's added when you file the non-provisional application. And the final question, can you explain how people can sell their products while the patent is pending? What if your application gets rejected later? Can you not then sell your product? Having or not having a patent has no bearing on whether you can sell your product. All it does is prevent others from selling your product if you have a patent issued. So you don't have to worry about not being able to sell your product because you have a patent pending and it gets rejected. Again, having a patent has no bearing on your ability to actually make, use, or sell your own products. Whether you can legally do that is going to depend on whether anyone else has patents that cover your product. Okay, and then that was the last question. Well, I hope that helped you guys. And if you have inventions that you need help with, I encourage you to apply for assistance through the California Inventors Assistance Program. I've been working with that program for many years now, and my firm, and I know a lot of other good firms that do work for Google and Amazon and Intel and all Fortune 100 companies down to startup companies, they provide pro bono legal services. So you get the same quality of work as these top companies are getting, if you get picked up by an attorney through this process.
Thank you so much, Ben, for your time and your expertise. And we thank all of you for joining California Lawyers for the Arts this evening. Have a great evening.
Thanks, everyone. Have a good night.